everyone. Good afternoon and welcome to LIBOR's Wednesday webinar. My name is Mary Ann Monteleone, Director of Education. This is April is Fair Housing Month, and we are celebrating and honoring and recognizing fair housing by dedicating each Wednesday webinar to fair housing practices in our industry. So to start us off this Wednesday is LIBOR Associate General Counsel Patrick Fife, who will talk to us about update on New York's new fair housing laws. Please feel free to put any questions in the Q&A, and Patrick and I will get to them and hopefully get your questions answered. So with that, I turn it over to Patrick. Welcome, Patrick.
Hey, Mary Ann, thank you. Thank you for having me, and thanks for everybody coming in. It's a timely subject today because New York has just introduced a series of new fair housing laws that I'm going to take you through. I'm also going to give you a refresher on some existing fair housing laws. But before I do that, I just want to let everybody know that it's very important that you stay on top of developments, not only in fair housing, but just the law in general. We work, or you work in New York State, which is a highly regulated state, and you're in a highly regulated industry, and the laws are changing all the time. In fact, some of the laws that I'm going to go over, you probably saw from NYSAR with the Reasonable Accommodation and Modification Notice. I mean, there was a change within a day on it, and I'll explain that, but you need to have a way to stay on top of changes in the law. And I think one of the best ways to do that is through our website and through our member updates. So if you go to lirealtor.com, if you're not getting our Friday updates, you want to opt into the communications. And then you can also go to our legal page where we have free member legal tips, where we cover all of this stuff and more. You can search through the legal tips. And they give you really kind of a basic understanding of different issues as they come up, as they change. Same thing when it comes to fair housing. Check out our Fair Housing Hub, lirealtor.com/fair housing. Some of the documents I reference here today will be on there. This presentation will be on the Fair Housing Hub as well, the slides that I'm going to use today, as well as the webinar. So it's just a good resource for you to take a look at if you have any questions on any of these issues or any other legal issues that impact you day to day. So with that, I'm going to talk first about the new fair housing laws that were signed by Governor Hochul on December 21st. It was a huge legislative package. There were 9 laws, all aimed at combating housing discrimination. And they specifically came out in response to the Newsday Long Island Divided article, which explored discrimination that existed in the real estate industry. And following that, the New York State Senate conducted an investigation, conducted hearings. And what the Senate found was there was a need for legislation to address 3 things. And those 3 things were more undercover testing. They wanted to see an increased training for licensees and also an increase in broker supervision. And out of the motive to see those things came these 9 new laws. And I'm going to go through each topic now and address what the laws cover exactly. So the first thing is testing. The state wants to see a greater emphasis on testing, paired testing, like the Newsday undercover investigators ran in connection with that article, but they want to see it from the state. And that type of testing is expensive. So the state has come up with the Anti-Discrimination in Housing Fund. And they are going to add money to that fund, and it's going to be dedicated solely for testing of real estate licensees. And they are going to fund that, that program through 2 things. One, increased fines for violations of the anti-discrimination laws. They are increasing fines from $1,000 to $2,000. And they're also adding a surcharge on licensing and relicensing fees, $30 for real estate brokers and $10 for salespersons. All of that money is going to go towards testing. And that is in addition to other testing programs that were already underway. Last year, Suffolk County set aside $140,000 for testing. New York State has had $250,000, I believe, the year before for undercover testing. So you are going to see a substantial increase in undercover testing by the state when it comes to fair housing. The second issue I mentioned was the state wanted to see a greater emphasis on broker supervision. And this law that has to do with office managers is already on the books. So as of now, any office manager must have been active as an associate real estate broker for 2 of the last 4 years before being designated as an office manager. The second thing, and this is a big point, I haven't heard a lot of people discuss this, but if you are an office manager or you're a broker, you really need to be aware of this. Office managers are now legally required to exercise the same duty of supervision over salesmen and associate brokers as the licensed broker. Before that language was added, the role of an office manager didn't really have any defined duty under the law. But now the state is saying if you're an office manager, you're going to be held to the same supervision standard as the broker. So what does that mean? If a real estate agent is brought up on charges before the DOS, I think it's very likely DOS is now not only going to name the principal broker, but also the office manager for a possible failure to supervise. So what does that duty of supervision mean? If you're a broker, you should know that, but you now need to know it if you're an office manager. The state legally defines that duty of supervision as regular, frequent, and consistent personal guidance, instruction, oversight, and superintendence by the real estate broker with respect to the general real estate brokerage business conducted by the broker and all matters relating thereto. So now brokers and office managers need to think about the procedures they have in place to supervise the actions of their licensees. It's not just the broker now who has that legal duty to supervise, it's the office manager as well. Now, this is the one that most of you are probably here for and that you may have read about. Effective in just a couple of weeks, effective April 20th of this year, all real estate brokers are going to need to institute standard operating procedures for the prerequisites that prospective home buyers need to meet before receiving services. So what do these standard operating procedures need to include? It's 3 things. That's what the state wants to see. You can include more, but at a minimum, these 3 things must be in a broker standard operating procedure. First is whether prospective clients need to show identification. The second is whether an exclusive broker agreement is required. And the third is whether a pre-approval for a mortgage loan is required. So what can the brokers do? Well, it's really up to them how they want to answer those questions. It's just they need to answer those 3 questions and they need to put it in a standard operating procedures. So it's up to the broker to decide what documents, if any, they want. They could say, we don't require any of those. They could require some of those. They could require all of those. So I gave you the example here. A broker standard operating procedure could say we do require identification, but we don't require an exclusive brokerage agreement and we don't require pre-approval. The key is these standard operating procedures have to be publicized, and I'll explain how, but they also have to be followed. All right. Once the broker says what the broker is requiring, it's got to publicize that, but it also has to follow it for every prospective home buyer. There's one exception. So the only exception to these broker SOPs is if a seller gave the broker a lawful instruction that differed from the SOP. And the example I give here is, let's say the broker SOP didn't require pre-approval. They have it in their published standard operating procedures. We don't require pre-approvals from prospective buyers. But let's say there's a seller who wants pre-approvals from each potential buyer before showing the house. Well, then the broker has to follow the lawful instructions of the seller. And this should all be explained to prospective purchasers in the broker standard operating procedure. I'm going to give you a link later to an example broker SOP that NYSAR prepared. And if you take a look at that, and I'm displaying it up on the screen, they have that note right there. You have the 3 different issues that you need to check. And then there's a highlighted section that says, although broker may not require such information, a seller of real estate may require this information prior to showing the property and or as part of any purchase offer. The SOPs, yeah, there was a question about the SOPs being required. Yes, it's for incoming buyers, prospective home buyers coming into your office. And again, if you're dealing with a buyer, as working with that buyer and the seller requires something different, you can follow, or you should follow the lawful instruction of the seller. As far as getting instructions from the seller, I would want to document it. I would want something in writing from the listing broker explaining this seller requires identification. That way, your client understands why you're deviating from your standard operating procedures. Now, this is key. This goes beyond just the brokers. All affiliated licensees must follow the broker standard operating procedures. So brokers have to communicate these to their agents, to their teams, all their affiliated licensees. A team can't just on its own say, we want to do something different. Everyone under the broker has to follow the same standard operating procedures. So if the broker's SOP doesn't require mortgage pre-approvals from buyers, no agent or team under that broker can require them. And this kind of puts the link all together. So if an agent fails to comply with the new law, it's possible there could be sanctions against the broker. This all ties into that broker's duty to supervise. So I mentioned displaying the standard operating procedures or publicizing them. There's a couple of requirements that the brokers are going to need to follow. First, you have to date stamp and notarize them and post them on any public websites, mobile apps, and have them available upon request at office locations. Any team website or mobile app also has to either post the broker SOP or have a direct link to the broker SOP. Where should it be on the website? DOS has always adopted what's called a clear and conspicuous standard. That means I shouldn't have to scroll through your entire website to find where the broker SOP is. It should be in a clearly obvious place. I'd recommend preferably at the top of the page. I'm going to talk later about the fair housing notice that hopefully you all are already aware of and have on your websites. It should be in that same location so that the customer doesn't have to struggle to find it. Question about what does SOP mean? It's a short for standard operating procedure. So anywhere I refer to SOP here in the slides, that means the standard operating procedures. So what if your broker decides they want to change their SOP? They can. This is not a one time you make the decision and you never can. You have the ability to change it. However, any alterations have to be date stamped. They must be notarized within 30 days, and the alterations have to be posted to all the websites and the mobile app. I see a question about where do we place it on a mobile app? That's going to be, you'll need to talk to whoever your web developer is, but the state wants to see it on mobile apps. If you have a mobile app, I think if you have a mobile friendly site, same thing. It has to be something that the consumer can see, and it can't be difficult to find. I mentioned getting a sample. NYSAR, the New York State Association of Realtors, created an example sample broker SOP. Excuse me. If you go to lirealtor.com/fair housing, that's our fair housing hub. That's where you can find it. And again, if you've got specific questions when it comes to how you need to implement it, you really need to speak to your own legal counsel, your own marketing department, when it comes to the way you need to display it on your particular website. It's not necessarily a one size fits all, where I say it's got to be on the upper right-hand corner. Make sure if you're a broker that you're communicating and speaking to your counsel and whoever's handling your website or marketing. So in addition to the laws I covered, there's a couple of other requirements that are going to be coming and that they're already passed. They just haven't come into effect yet. I mentioned training was the third thing that the state wanted to improve. And in doing so, the state is now requiring, as of September 21st, that all licensees in connection with their continuing education have to take 2 hours of implicit bias training and 2 hours of cultural competency training. So if your license expires after September 21st, you will need to have taken those 2 courses before you renew. This is in addition to the already existing requirements. So you have 3 hours of fair housing, you have 1 hour of agency, you have 2.5 hours of ethical business practices, and 1 hour of legal updates. This is in addition to that. The total 22.5 hours, that has not changed, but these are required courses now within the 22.5 hours. I got a question the other day when I was teaching my class, how can I take these classes now? I know LIBOR will be offering them soon. They just haven't come out yet because the state just passed the law. And when we offer a class, it has to get approved by the Department of State. So once Department of State starts approving these courses, I think you'll likely see them and be able to take them. In addition, one other area of training that the state wanted to change, and it will be changed effective December 21st, is that pre-licensing broker and salesperson course hours have now increased. So the pre-licensing broker is now 152 hours, and the salesperson course will be 77. Again, that's effective December 21st of this year. And there'll also be 6 hours focused on fair housing for salespersons. And I mentioned at the beginning, you really need to keep on top of these things. There will likely be more laws. I know there are a lot of other laws pertaining to fair housing that have been proposed. Some have been passed by the Senate, some have been passed by the Assembly. They just haven't been signed by the governor yet, but I would expect that there may be more coming. This is just the whole group that was passed in December and is either in effect or about to come into effect. I also want to talk a little bit about something that is coming. It's not in effect yet. And this is a new disclosure form for rental properties. I mentioned earlier that you may have seen an update from NYSAR. If you get the email updates, there was a NYSAR flash update that said this disclosure form was now in effect. The next day, another update came out and said, no, the state kind of gave us wrong information. It will be coming online soon, but it's still open for additional public comment. So this is not in effect yet, but it could be within the next month or so. And I want to make sure everybody understands what's coming and gets ready for it, because this is another disclosure form, and it also has obligations concerning putting information on your website. So this new disclosure form has been talked about for a while. It was actually last year that then Governor Cuomo signed a law that said the Division of Human Rights needs to come up with regulations and a notice for reasonable modifications and accommodations in tenancies and housing accommodations. So this came out. DHR took a while to come up with a proposed notice, but it just recently did. It published the notice, but there's still additional public comment time before the notice becomes official and is required. So again, it's not required yet, but eventually all prospective and current tenants in New York are going to need to be provided a reasonable modification and accommodation notice. Just hang on one second. I see, I'm going to go back. I know there's some questions here about the broker SOP. So I'm going to go back and take a look at those. I want to get through this and then I'll come back to the broker SOPs. So the reasonable modification and accommodation notice, it applies to housing accommodations. And that is any building structure that is being used or occupied as a home, residence, or sleeping place. And it is a notice that lets tenants know, or prospective tenants know, they have a right to request a reasonable modification or accommodation. So what are those? Well, a reasonable modification, it's a change, a structural change to the property. And a tenant with a disability has the right to ask for a reasonable modification. Very often it's at the expense of the tenant, but the landlord needs to allow for it. And the common example is a grab bar, a handrail, something like that. Reasonable accommodation is a change to policy. And I think the best example to that is a change to a no pets policy. A landlord may have a no pets policy, but they have to make an accommodation to someone who requires a service animal or emotional support animal. So the state has said, we want tenants to know that they have the right to ask for these things. So they've created this disclosure notice. And once it comes out, it's going to need to be in writing. It's going to need to be something that you provide to prospective tenants at first substantive contact. So that's the same standard you use for the agency disclosure form, for the anti-discrimination disclosure form. If you engage in any real meaningful conversation with a tenant about a potential rental, you would need to provide them this disclosure notice. How do you need to provide it? You can provide it in just about any way. It's going to be email, text, electronic messaging, fax, hard copy. If you send a link, you're allowed to do that. You just need to let the prospective tenant know that it contains information regarding the tenant's right to a reasonable accommodation for persons with disabilities. Basically, the only way you can't comply is by just orally disclosing it or posting it somewhere on a bulletin board. Once this goes into effect, the recommendation is that you would provide this to all prospective tenants, letting essentially every tenant know that if they are disabled, they have the right to ask for a reasonable modification or a reasonable accommodation. In addition to providing this notice to prospective tenants, there also is going to be a requirement that you post this on websites, you post it at housing accommodations, and you post it at real estate offices. So on websites, just like I mentioned, for the broker SOP, it's going to need to be in a prominent and conspicuous location. You'll need to display a link to the reasonable accommodation notice. Same thing at housing accommodations. And that's, again, housing accommodation is the actual physical rental location. It needs to be posted conspicuously in an easily accessible, well-lit place where it can be readily observed. Same thing with real estate offices. It's another notice that's going to need to be posted, and it has to be posted in, again, conspicuous, easily accessible, well-lit place. There also is a requirement that the owners and landlords are going to need to provide this notice to their current tenants and tenants upon signing a lease. They also are going to need to post the notice at rental locations. You as the landlord agent should not be advising, though, the housing providers on how to comply with that. That's their obligation. And if there are questions about how the landlord needs to comply with their own obligations, you should be telling them to consult with their own counsel. So that's it for the new laws that are either in effect or about to come into effect. I do want to just spend a couple of minutes before I go back and take a look at some questions. I want to do a quick refresher on New York State's fair housing regulations, and specifically the New York State Housing and Anti-Discrimination Disclosure Form, and also the New York State Fair Housing Notice. I see just a lot of questions come up about these. This has been in effect for almost 2 years. But I think that there still is some confusion in the field, and people are not necessarily meeting the requirements. And this is something that DOS looks at. We've heard the attorneys who represent a lot of the associations have heard from attorneys who represent licensees and proceedings before DOS, that DOS does look at this. They want to make sure that there is compliance, and they will look for compliance, even if they're looking at other issues unrelated to the disclosure form. They're going to ask to see proof of it, that it was either signed, that it was provided. So I just want to quickly go over what the obligations are and what you need to be doing with respect to these forms. So this is the anti-discrimination disclosure form. I hope you are all familiar with it, that you have seen it. And it's because it's a form that you must be providing to every consumer, again, at first substantive contact. That's the same standard as presentation of the agency disclosure form. So if you engage in any substantial way with a customer, you need to be providing it to them. So if you're talking about taking a listing in terms of a listing, that's when you'd be providing it. If you're talking to a buyer about price, terms, that is first substantive contact. It applies to all properties. It doesn't matter. It applies to commercial. It's not just a residential form. And I encourage all of you to read it. You should understand it. What does it do? It's, you get in that habit of just mechanically giving forms to your customers, but you should really understand it. It's an important form. It explains to the consumer what the human rights law is. What are their rights? It also explains to them how complaints can be filed. So you as a licensee should also read it, understand it, and be able to explain it to your client. You can present it in just about any way possible. Again, the only thing that wouldn't satisfy is if you orally read it to the client. You can also provide a link. You can do it through your smartphone if you want, but you have to then explain that the link contains information regarding the human rights law. Do you have to get it signed? Well, if you give it to someone in hard copy, yes, you need to get it signed. If you send it any other way, you just need to keep proof of delivery, proof of transmission. So if you send it by email, if you send it by text, you need to keep proof of that email or text. And this is something that DOS will ask for. Again, it's something on an audit they may ask for. And the records have to be kept for a period of not less than 3 years. So I pause and I say, if you're somebody who uses the smartphone a lot to send things, you need to make sure that you're backing up your records. A lot of people have their text messages set to auto delete after a year. If that's the case and that's your practice, you better make sure that you're backing them up somewhere else before they auto delete off of your phone. You have an obligation to keep proof of transmission for not less than 3 years. So good practice is make sure that you're backing up your email, your text messages, if you're using those to communicate and send forms like this to clients. What do you do if someone won't sign it? Let's say you have a customer, you meet them, they haven't signed the listing agreement yet, and they just say, I'm not signing anything. I don't sign documents. I don't want to, you're trying to trick me, whatever the case might be. It happens, right? There is an obligation then that you, under oath, have a written declaration that says you provided this consumer the notice on such and such a date, and that you explained it to them, and that they refused to sign it. And you are required to keep that declaration for not less than 3 years. If you go to LIBOR's documents on demand page, we have that available, that declaration. We also have the anti-discrimination disclosure form. So go check that out. And again, this is something that DOS will ask for. If you don't have a signed form or proof of transmission, they are going to want to see that you have this declaration. So I am now going to just wrap up just talking about the fair housing notice. which again, I hope everybody's familiar with, and just a couple of tips as it relates to the fair housing notice. This notice has to be prominently displayed at every office and branch office operated by the broker. And it has to be prominently displayed. So that means it should be in the window. If you have access to a sidewalk, if you don't, it's got to be prominently displayed in the same location the business license is posted. And there are two other places where it must be displayed. The first is at open houses. All open houses of real property, you must be displaying this notice. And it again should be displayed in an area where everyone can see it, conspicuous, prominently displayed. Also, you are required to have additional copies of this notice available at open houses and showings to provide to consumers when requested. My advice, I would give this to every consumer. I don't see any downside in doing that. You're not required to. But what better way to say, you made it available to every consumer by actually giving it to them? I think it certainly makes sure that you are in compliance and eliminates any question that you didn't have the form available. The other place where it must be displayed is all websites created and maintained, not just by the broker, but any associate real estate broker, any salesperson, any team working under that broker has to prominently and conspicuously display the notice on the homepage. And they can do that by displaying a link to the fair housing notice. And I underline all websites because that includes social media if you're using those platforms to advertise. I think a lot of licensees look at social media differently. It's easy to use. It's quick, it's convenient, but you need to be treating those platforms just like you would your company website when it comes to displaying this notice and when it comes to advertising in general. The Department of State doesn't look at social media any differently. It still is advertising, and it still is considered a website that is being used and maintained for the purpose of advertising listings. So you should be on your homepage for, if it's Facebook, Instagram, whatever it is, if you're using those platforms to advertise, you have to be posting a link to the fair housing notice. And again, the link should be easy to find. It shouldn't be something that I have to go and find in the fine print under your terms of use or your copyright notice. It should be in a spot where the consumer could see it. So the last thing, I started with it, I'll end with it. I just want everybody to be aware of the different legal resources that are out there. There's great material, not only that we put out, that NYSAR, NAR put out, the New York State Department of State, New York State Division of Human Rights. Just periodically check into those places because there's just a lot of great material when it comes to fair housing and understanding what your obligations are as a real estate licensee. Last thing before I take a couple of questions through the Q&A, because I see a couple there that haven't been answered yet. NYSAR has a legal hotline. It's a free member benefit if you're a member of LIBOR. It's available Monday through Friday, 9 a.m. to 4 p.m. for general legal questions. The number's 518-43-NYSAR. And again, it's a free benefit, and you should certainly take advantage of it if you have any questions when it comes to the application of these laws when they become effective, that type of thing. So I do see a couple of questions, and I'm going to just, if you bear with me, if people want to stay on, I'll take a look and just double check what I haven't answered. Let's see. So somebody asked, this goes to the broker standard operating procedures. I see a lot of questions here. Somebody asked if a broker elects not to have pre-approvals, but the listing agent's demanding one to make an appointment. How do we overcome that? Well, that's when you're following the lawful instruction of the seller. I mean, the seller has the right to request that. I would just have it documented somewhere in writing. Let's say that instruction from the listing agent. If it's not in the remarks, you want it documented somewhere in writing so you can put it in your file. And then you just tell your client that the seller in this case, although we don't require it, the seller is requiring it. And then you get it from your buyer. Somebody asked what needs to be notarized. That broker standard operating procedure, the example that NYSAR provided, whatever standard operating procedure you adopt, that has to be notarized. It has to be put on the website. The notarized copy needs to be put on the website. And if you make any alterations, those need to be notarized. And that should then be put on the website as a replacement. Good question. Somebody asked about if you do get that instruction from the seller, can it be verbal? I'd recommend that you get something in writing so you protect yourself. That way there's no question that, your deviation from your standard operating procedure was at the direction of the seller. Standard operating procedure, where can I get it? Again, the question, I think I answered it. If you take a look at lirealtor.com/fair housing, we've posted the NYSAR standard operating procedure. It's also, or example standard operating procedure. It's also available on NYSAR's website. They've been, kind enough to make that available to everyone. The standard operating procedure, does it have to be on the MLS listing? No, there's no requirement for that. This is not an MLS rule. Again, the requirement is that it needs to be on any websites that the broker or their associated licensees maintain. There's no requirement that all agents sign the standard operating procedure. You certainly can adopt whatever internal procedures you want, but all agents, anyone working under the broker, must follow the standard operating procedure. So as a broker, as an office manager, you need to find a way to make sure that everyone working under you knows what your standard operating procedures are and they follow it. I see a question about, does the standard operating procedure have to be submitted to the state? It's a good question. The answer is no. Originally, the law was set up that was going to be a requirement, but that was eliminated. The standard operating procedure does not need to be submitted to the state. But again, you have to notarize it, archive it, and have it available for inspection. So I guess if the state ever did audit you, they could ask for it. Let's see what else. Sorry, I'm just scrolling through the questions. All right, this is a question. If a person who isn't disabled they can be denied if they can't add a wall. So yeah, reasonable, I guess this is a question about reasonable modification. Someone is asking if just a tenant generally asks for a modification, can the landlord deny it? The answer is yes. It's just if the person requires a modification due to a disability, a reasonable modification, then the landlord, can't outright deny it. And I would caution all of you, if questions come up about what is a reasonable modification, what is a reasonable accommodation, you should not be making that determination. That's a determination for the landlord to make. It's a determination they should be making with their attorney. It's those types of questions are very fact specific. I've taught legal update class and I get asked all the time, I've got this one matter where somebody wants to do this and that. You as a real estate licensee should not be weighing in on that. That's an issue for the landlord to deal with the tenant, and I would recommend that they speak to counsel. These reasonable modification questions can be very fact specific, and they're certainly not something that you as a real estate licensee should be providing legal advice on. Does the modification and accommodation notice also pertain to single and two family homes? Yeah, if the property is a rental that is being listed with a broker, you have an obligation to provide it, even if it's a single family or a two family home. I've got a question. Does first substantive contact include phone calls, emails, text messages, direct message from social media with the consumer? That's a great question. And I'm sorry I didn't answer it before. It can. It doesn't just have to be personal contact. So first substantive contact, if somebody is texting with you and getting into, or even through a social media site and getting into questions about price and terms, yes, that would be considered first substantive contact. And in those instances, you would want to provide the agency disclosure form. You would want to provide, the New York State anti-discrimination disclosure form. So yes, that's a very good question. Let me see what else we have here. If a buyer has an agent and the buyer attends my open house, do I also have to have them sign the fair housing form, or is that only for their agent to do? Again, if somebody comes to your open house, that is not necessarily first substantive contact. It's only if they start discussing, price and terms. And I would say yes. I mean, if somebody comes and they do have an agent, and they are then discussing at the open house price and terms with you, even if their agent's there, I would want to present the form to them, because you don't know if that buyer has signed an anti-discrimination disclosure form with their agent. So anytime you are having substantive discussions, I would at that point present the disclosure form. Somebody asked if this class, if we will have it again, it's going to be up on the website, lirealtor.com /fair housing. The webinar will be up, and we will also have the slides posted. So I see somebody asked about if I could put the last slide up, and I'm sorry, I couldn't look at some of these questions in real time. Again, the slides will all be posted to the website. So if you missed anything, you can go back and look at it. Let me just see a couple questions. Couple of these questions are a little more specific, related to people's individual business. And again, if you've got questions about implementation of the broker standard operating procedure, you really need to make sure that you consult with your own attorney. You can't, if you've got a question, you definitely should consult with your attorney. You don't want to take the chance on something like this. Do we have to put the fair housing notice in a newspaper ad? No, newspaper, no, it's not required for that. That fair housing notice that I showed, it has to be displayed at your office. It has to be at open houses, and the state has said website. So a newspaper ad would not apply. There's a question. What if a buyer won't sign a buyer broker agreement and that is our requirement? Well, again, if you require it and that's in the standard operating procedures, the broker is going to need to follow that procedure. That's the whole point. The state was concerned when it conducted its investigation and what it saw on Newsday, that there were instances where agents were treating customers differently at different times. Different agents within different offices were treating customers differently, and in some instances weren't aware what the broker's policy was. And that's what the state wants to eliminate. They want one policy from each broker and everyone working under that broker following that policy, period. Somebody asked about displaying the fair housing signs if you're now working from home, or just give them copies of it. Look, if you're having customers come into your home, and that's considered an office, I don't think the state would make a distinction. I would say anywhere where you're having the public come into an office for the purpose of engaging in any discussion about real estate with you, you would want to have that fair housing notice posted, just so you're covered. And again, I'd also recommend that you give a copy to every customer. I don't see the downside of it. All right. I think that's it for questions. Marianne, do you see anything else? I tried to go through them all that were in the chat, and I don't want to keep people here too long. Oh, I think that's it then. So with that, I thank everyone for being here. And certainly, like I said, if you have questions, don't hesitate to contact the NYSAR helpline, or also take a look at our website where you can get answers to many of these questions and more information on each one of these topics. So thank you, everybody. Have a great day.